be seated.
Recording in progress.
Madam Reporter, can you hear me?
Yes, sir, Judge, I just can't see you.
Okay, I'm trying to turn on the camera now. There we go.
Perfect.
All right, the court will call up, well, first of all, we'll go on the record this 18th day of July 2025, Judge Brower presiding. Court calls up State of Idaho versus Jason Earnest Stark, CR 03-24-04391. Mr. Stark is being represented by Kyle May, and the state is being represented by Dan Taylor. Good morning, gentlemen.
Good morning.
We are scheduled for a sentencing today in this case. There was a pre-sentence investigation report that was filed with this court on the 16th day of July 2025. Mr. Stark, have you received a copy of that report?
Yes, Your Honor.
And have you had an opportunity to review that report with your counsel?
Yes, Your Honor.
Mr. May, was there any factual corrections or errors contained in that report that you wish the court to take note of?
Yeah, specifically there's some minor ones, but one of the biggest ones, and that was on page, and it was mostly on the PSE
Okay.
that was submitted to the court. It was on page 8, I believe.
Right over there.
That last paragraph on page 8, where it starts in May of 2024, Mr. Stark's cell phone was reviewed and contact information and nude images of 2 of the 6 accused victims were found. So that is incorrect. There was, at least from our standpoint, we had never received anything. The state had no images, nothing like that. They had search warrants, they had things like that were issued on that. In discovery, we never received anything like that in discovery. There were never any images or anything like that found on his phone from what we had received in discovery. So that is an incorrect statement on page 8.
Just a second. Mr. Taylor, any objection to that correction?
No, Your Honor.
All right, Mr. May.
And then just on page 7 on the PSI, there was a couple of things. He said never received a degree or certificate. You received a degree in AAS, which is Associates in Applied Science, and a certificate in auto body. You wanted the court to know that. Employed as a supervisor at Lifetime in, it says Idaho, it's supposed to be Utah. And in there it says that he does not belong to any social or community organizations. He is a member of the LDS Church. And those were basically the corrections that we wanted the court to take note of.
Okay. I will take note of those corrections and I will enter an order that will attach to the PSI making note of those corrections as well. Mr. May, are you prepared to proceed with sentencing?
Yes, Your Honor. I guess I know this court has been presented a binding Rule 11 agreement. I know the court was going to wait to pass judgment on that, pending looking at the PSI, the pre-sentence investigation report, and the psychosexual evaluation report, and then the court was going to make a judgment as to if this court was going to follow the binding Rule 11 agreement. And so I just asked the court what its position is on that.
So the court already found itself with the, as you stated, the option to choose to not go along with that after the PSE and the PSI. I'm not going to exercise that right now. Well, I'm not going to exercise that. So we will continue with the binding plea agreement as stated. And
Okay.
the sentencing recommendations contained therein.
Okay, thank you, Your Honor.
Yes.
So, Your Honor, I guess with the court following the binding Rule 11 agreement, pursuant to that, obviously, I guess would just follow with that is that the defendant here is going to be incarcerated as part of the agreement. He's going to go and do a 10-year fixed sentence with a 20 years indeterminate. And one of the things that we wanted to point out to the court is he was arrested on April 25th of 2024. That was when the warrants were executed in Utah. He didn't get here till like May 6th, I think, on the criminal complaint. But that would be 449 days of credit served up to this point. I think at this point with the court following the binding Rule 11, the court has discretion with the amount of fines. I would just take into consideration because this is a 30-year sentence, and obviously 10 years of that he's going to be at least incarcerated, potentially more. I would ask the court to consider the amount of fines and I guess not additionally punish the defendant here in this case because he's going to be incarcerated for a quite lengthy period of time to be able to even pay those. And so I would ask the court to institute a lower fine in this case. I think obviously the sentence is reasonable, Your Honor, and that the court follow it obviously through the pre-sentence investigation report and the PSC. Obviously he came back moderate on the PSC and he came back actually low on the PSI with regard to the recidivism rate. With that too, obviously the court taking into consideration the last time when Mr. Stark was on parole, he actually did well before anything happened again. And because there's going to be that long 20-year tail, I think the court can rest assured that he will be supervised, and if he's ever released, that there'll be someone there supervising him for probably the majority of his life. Thank you, Your Honor.
Mr. Stark, is there anything that you would like to say to the court in allocution?
No, Your Honor.
All right. Mr. Taylor, turn to you.
Your Honor, there are 2 victims here today. Before I go that far, all named victims in this case have been notified pursuant to statute. 2 of them have exercised their right to be present today. I believe one of them would like to make a statement to the court. And their mother is here as well. And that puts us in something of an unusual spot in this case because the parents of juveniles, as the court's aware, qualify under the statute, but they're no longer juveniles. But they were juveniles at the time the offenses were committed. So their mother is present, and she has requested that I ask the court if she'd be allowed to make a statement in regards to what was going on when they were juveniles and when these events were taking place. I said I didn't know the answer to that, and I would leave it to the discretion of the court.
All right. Mr. May, any comments on that?
I mean, I guess, Your Honor, is where we're at is that obviously we would be in the position of, look, they're adults now, and they have the right to do their victim impact statement, and that's where we would be at. I mean, I guess if the state wanted to call, I mean, should they have the right to call witnesses in this if you wanted to call her to give that victim impact statement, he'd have that right. And I would just say, but with just coming up and doing a victim impact statement, we would just ask that the victims themselves do it, Your Honor.
Thank you. I am going to allow the mother to speak in regards to a victim impact statement. She, having been present during the time of the child's life under which this was occurring, I do think would have insight in regard to how that impacted the victim, particularly since children's perceptions can certainly change or be altered throughout adolescence. And so in regard to the impact on the victim, I do think that's appropriate, so I will allow that.
Very well, Your Honor, in this case, but the state believes it's important to make a record of a few things. So in regards to the psychosexual evaluation, I think one of the most important things is actually the second sentence of the first page under preliminary statement. Risk classification is the examinee's assessed risk to reoffend when compared to other sex offenders, not the general population. He's been tagged as average or moderate. Dr. Hatzenbuehler uses both interchangeably. They mean basically the same thing, but that is in regards to other people like him, not to everybody else. And we know that he's already reoffended. This is the second time, as the court is aware. So the sentence that we have agreed upon is fair, and it certainly, I think, reflects what needs to happen in this case. This was a premeditated and substantial period of grooming that occurred. In a lot of ways, grooming, at least from the state's position, is at least as harmful and potentially more harmful than just a physical assault that results in this sort of conduct. Because what he's doing is he's eroding their self-defense mechanisms. And at such a young age, he's almost preventing them from being fully formed in the first place. By gaining their trust and then using them to fulfill his own needs, the victims will not have the same mental processes as people who weren't subjected to this sort of behavior. And I think it's important to note that he did so under the guise of being their friend. He went to the mall as a man in his early to mid 30s and played Magic the Gathering with kids that were in middle school. And he didn't do it because he wanted to spend time with them. He didn't do it because he wanted to make sure there was an adult there to be looking out for them. He did it so that he could take advantage of them. That's the same. That's almost the same thing as the proverbial van that says free candy on the side. That's the man that we're dealing with. One of the things that I found most troubling when going through the materials, the psychosexual evaluation, the PSI, is when he sits down with Dr. Hatzenbuehler. The very first time he says, well, I didn't really do anything. There were lewd comments I shouldn't have made. And then as the process goes on, there's a little, he says, well, okay, I touched him and I shouldn't have. Well, I just did it with the one kid. Throughout the psychosexual evaluation and the pre-sentence investigation, he is downplaying his actions and victim role. He continued to maintain that his only contact offense involved the touching of one of his accusers on one occasion, and that the one sexual harmful contact with one of the 6 boys occurred 1.5 years after interaction with a group of boys. And then he takes it a step further and says, well, when one of the victims moved in with me and I had to kick him out because I was getting married, then they all came after me, and that's why there's 6 accusers. Fine, all right, so that might account for 2 because they're brothers. But why would these other kids say that these things happened if they didn't? They have no motivation to do so. This is him deflecting, this is him downplaying, this is him not taking responsibility. He pled guilty to the 1 count, but I don't think he has fully internalized, probably because he doesn't have the tools to do so, exactly what it was he did and how harmful it was. He really, I would like to say that that's fixable, but he's already, I don't know anything about the laws from the state where this happened before, but I think it's safe to assume they have some similar mechanisms to what we have here, and they didn't work the first time. So that brings me to the 2 bill factors in Idaho Code 1925-21. As the court is aware, community supervision is supposed to be the go-to. None of the things under 1925-21 sub 1 apply. The defendant's criminal conduct neither caused nor threatened harm. We know it did. We just heard from one of the victims. The defendant did not contemplate that his criminal conduct would cause or threaten harm. He spent years grooming these kids. He knew it was going to cause harm. He just didn't care. The defendant's criminogenic needs indicate the defendant will benefit from supervision and treatment in the community. It didn't work the first time. We know it did, because he reoffended. The victim of the defendant's criminal conduct induced or facilitated the commission of crime. They were minors. That's not applicable. And in regards to sub F, that's not even possible. But what is important, section 3, the following factors, while not controlling at the discretion of the court, shall be weighed in favor of imprisonment. And he checks all of them. Undue risk that during the period of suspended probation, the defendant will commit another crime. He's already done that. We've already been there. A lesser sentence would depreciate the seriousness of the crime. Absolutely. Anything less than prison says that this is okay. Imprisonment will provide appropriate punishment and deterrence to the defendant. Well, I hope so. I hope this doesn't happen again. And finally, an appropriate deterrent for other persons in the community. Yes, absolutely. The court has already said, yes, we're going to send this message. And then the very last thing, multiple offender. Yes, he is. So I don't want to take up a lot of the court's time by going through with a fine-tooth comb everything. But there's certainly enough here that makes this justifiable. And that's why we came to the agreement that we did. And again, the state thinks it's fair and appropriate. So, thank you.
All right, Mr. May, is there anything else from you?
I guess I'm just a little bit confused, Your Honor. I don't, from our standpoint, we're arguing that the binding rule 11 is fair. I think the court thinks it's fair, the state thinks it's fair. The rule 11 basically says he's going to be incarcerated. I think at this point we've come to that agreement, and that the agreement supports an appropriate sentence in this matter pursuant to all the factors. I could get into the details of some of the things that were beneficial for him, but at this point I think that's moot at this point due to the fact that there's an agreement. The court is accepting that agreement, and so is the state. And so that's where we're at, and I think it's appropriate, and I think that my client, we spoke with him, and he has made this agreement, and he's okay with it. And that's where we're at this point in time. He does, I think in there's specific things that he says that he is going to plan on doing to try to improve himself while he's incarcerated, and do the treatment programming that has been recommended throughout the PSE and the PSI, and he plans on doing that while he's incarcerated to be able to overcome some of the things that and challenges that he faced with addictions and things like that he has, and he understands that he has those. And I think he understands that it would be appropriate at this point in time to be able to do that and while he's incarcerated for the period of time that he's going to be. Thank you.
Thank you. Mr. May, is there any legal reason that you're aware of that the court should not proceed with sentencing?
No, Your Honor.
Mr. Tate?
No.
Okay. Then the court does consider the 4 factors of criminal sentencing in this matter: punishment, deterrence, protection of society, and rehabilitation. Protection of society being the most important factor that this court must consider, with the other 3 having great weight. I also considered the pre-sentence investigation report, the psychosexual evaluation, the attached documents to the pre-sentence investigation report, the comments of the victims and one of the victim's mother. The reports and information attached to the complaint, and other information that has been appropriately provided to this court. I also consider the recommendations and statements by counsel, as well as the binding plea agreement. I do want to address one thing, I suppose, before I begin. Mr. May, you said that parties think that this plea agreement is fair, and then I wrote it down, the court thinks it's fair. I actually do not. I have accepted this plea agreement. And there are reasons the court accepted this plea agreement. I recognize, having done this for a long time, that there are often different considerations that the parties take into account that the court doesn't have information about. There are issues of evidence, there are issues of the impact on individuals if they are to go to trial. There are a lot of different things. From the defendant's side, they have different considerations in relation to the likelihood of a conviction, for example, versus being able to receive a lower sentence. These are all different matters that are not taken into consideration by this court. But I do take them, I do take binding plea agreements with a certain amount of weight because I'm not in that room. I'm not in that room at mediation. I'm not in that room when these things are being decided. I don't have access to all of the documents. What I did ask at change of plea was whether the victims had been notified and took part in the mediation and the plea agreement as required under the Constitution and by statute, and it was affirmed that they had. And that was important to me as well. But to be quite frank, Mr. Stark, based on your conduct, you likely deserve more than 10 years next. I've agreed to that, and I'm going to follow that agreement. But your conduct was egregious. Just as stated in this courtroom today by that mother, by that victim, you have ruined lives. Your conduct was selfish. Your conduct disregarded what would happen to other people for your own sexual proclivity. You groomed these children, and they will bear those scars for the rest of their lives. And you did so, even having done so before. Even having been through treatment, having understood what this could do to somebody, you, over the matter of a great deal of time, this wasn't even just a single instance, groom these children. The court does consider what you pled guilty to. I also consider the circumstances that are surrounding these instances. I look at the polygraph examination that you completed. In which the first question, was victim 1 telling the truth when he says you had hands-on sexual contact with him up to 100 times? Your answer being no, and a significant reaction. In layman's terms, that means that you failed that question. It was inconclusive that you had hands-on sexual contact with other juveniles, but later on, when you were asked whether, other than the ones we've discussed of your accusers, have you had hands-on sexual contact with any others? Significant reaction. Other than your accusers, have you ever received, to your advice, naked pictures of any of those boys? Significant reaction. Now, I know that polygraphs aren't infallible, but I also recognize that we use those as an indication of risk. I find you to be a great risk to this community. find that you harmed those children. I find that you did so without consideration of what it would do to them. I find that you are deserving of punishment, and that this court must enter a sentence that will protect society. That's a great reason why I accepted this plea agreement. It's the reason I did not back off of it after reading this information, because this plea agreement at least guarantees that you will be incarcerated for the next 10 years, as you deserve. And potentially for another 20 after that. I don't find either, oh, I guess I do find, I don't think you've taken accountability. Not entirely for the conduct that you committed. I agree with Mr. Taylor. I have a hard time believing that 6 young men would come out and put themselves through this. Potentially put themselves through a trial. The shame and the hardship that these things incur, simply because they wanted to get back at you because one of them was kicked out of a house. That simply does not compute. Another one because the other one you stated because he had disclosed things to a treatment counselor, that must be the reason. That does not make sense. I don't believe it makes sense. I've reviewed this information. I find their statements to be credible. And here, you have admitted to committing a lewd act on one of these children, to soliciting other acts at a minimum. And you even said here in your polygraph that had you been provided the opportunity, you would have taken it. You are a risk to this community. And quite frankly, how dare you commit this kind of conduct on children, young teens. I do impose on you in count 1 a 10-year fixed 20-year indeterminate sentence for a total unified sentence of 30 years. I'm going to impose that sentence. I will grant you 449 days time served as set forth by statute and required by statute and the plea agreement. I'm going to run that concurrent with count 2. I'm going to impose a fine in this case that is indicative of your conduct. I have considered this amount, whether you'll be able to pay back this amount. I consider your age and your employability after incarceration, and I find that this fine is appropriate given the circumstances and those 4 factors. So I will impose a fine of $10,000. I'm going to impose court costs as set forth by statute. I'm also going to impose a $5,000 fine pursuant to Idaho Code 19-5307, which shall act as a civil judgment against yourself and entered on behalf of PN. The court issues this, or will issue this as a separate order, imposing this fine on behalf of the victim. This fine is ordered solely as a punitive measure against the defendant and is not based on any requirement of showing of need by the victim, and it is unauthorized under subsection 2 of that section. In count 2, I will impose 10 years fixed, 0 years indeterminate. I will impose that sentence and run it concurrent with count 1, and I will grant you time served. I will also in that count impose a fine of $10,000. I will impose court costs as set forth by statute. I'm also going to impose a fine of $5,000 under 19-5307, which shall also act as a civil judgment against yourself and will be entered on behalf of EB, KL, GN, KN, and JC, with $1,000 being apportioned to each of those victims, as the statute limits the fine and that charge to $5,000. Elsewise, I would probably enter more. Court will also issue again a separate order imposing that fine on behalf of those victims. The fine is ordered solely as a punitive measure against you. It is not based on any requirement of showing of need by those victims and is authorized under subsection 2 of that section. Mr. Stark, I've entered this sentence against you within the bounds of that plea agreement for the reasons I've stated. Someday you'll see the light of day again after you're released from the Department of Corrections. Do not consider ever taking this action again. There need not be another victim that have gone through what these victims have gone through because of your actions. I sincerely hope that you engage in the counseling, the self-reflection that you need so that this will never happen again. I sincerely hope that you internalize what you did. You come to grips with all of it. Because I don't think you'll be able to change unless you're able to acknowledge the extent of your actions and what you've done. Because my part's done here. It's on you to make sure that you don't harm another person. I can say that I appreciate the bravery of those young men coming forward. It could not have been easy. One of my concerns, honestly, it took 10 years before these allegations came out. Even in the psychosexual evaluation, the PSI, it said that your risk was mitigated by the fact that nothing has happened since. I sure hope that's the case, because it took 10 years for this to come out. But I don't take that into consideration here, because I don't have that before me. But I certainly do find that you're a risk, that I must protect society, and that you deserve to be punished. So I am entering that sentence. I will enter a judgment reflecting that sentence. I will remand you to the custody of the Department of Corrections so that you may serve that term. You have 42 days in which you may file an appeal. If you cannot afford the cost of an appeal or the cost of an attorney to assist you in that appeal, those costs can be provided for you. Gentlemen, is there anything else?
No, yeah, nothing. Thanks.
Mr. Taylor?
No, Your Honor, thank you.
Thank you. All right, then, as I stated, you are remanded. The court will be off the record until 10:30 for our next hearing. Thank you.
All rise for the court.